and welcome to Defending the Windy City with experienced attorney David R. Drwencke. David has committed his career to criminal defense and takes pride in working for those individuals accused of crimes, and doing so in a passionate and non-judgmental way. I'm your host, Abigail Vaca, and today is part 2 of our discussion on high-stakes defense, strategies for serious drug charges. Thanks for joining me again today, David.
Thanks for having me.
So, David, to start, can you explain the different types of serious drug charges cases that you handle and how they differ in terms of severity and legal consequences?
Absolutely. Drug charges in Illinois really can run from the least serious to the most serious, meaning there are drug offenses that are simply misdemeanors that are very unlikely to ever end in any type of jail time, more likely to be a fine, maybe community service, and are eligible for a lot of deferred types of programs. But then there are other drug offenses that go from the least serious to most serious felonies. And in Illinois, we get very granular in how we break down our felonies. It starts with a class 4 and then goes 3, 2, 1, all the way up to what we then call a class X felony. And as you go from 4 up to 3, 2, 1, and X, they're more serious, meaning there's more serious punishments. And there's a few different factors that go into what makes a drug offense more or less serious. And typically, they really can go into one of 2 or 3 buckets. And what I mean by that is sometimes it's what substance do you have? Are we talking about cannabis, or are we talking about methamphetamines, or are we talking about something that may be laced with fentanyl as an example? That can make it more serious. What type of drug are we talking about? What are they alleging you've had? And then the amount is usually the other big triggering portion of this. So yes, you had cannabis, but you had a lot of cannabis. So it can go from something that most people don't have any problem with, or at least the recreational use of cannabis is legal in Illinois, but there's still some idiosyncratic things and subtle parts of the law that not everybody understands. But if you have too much of it and you're transporting it in the wrong way, even cannabis can be very, very serious. But then the other types of drugs that most people understand or know are just illicit. There's really no legal way to possess or use or distribute them. Well, not only is it more serious because of what they are, but if you have a lot of them, it makes that case very serious. The last, if you want to call it a bucket or thought, is, are you being charged with merely possessing the drug, that you had it? You had it on your person, or another topic we'll talk about is constructive possession. Or are you being accused of distributing it? Are you trafficking this? Are you not only possessing, but the intent is to sell and distribute to other people? That can make a big difference as well.
Okay, so it's not one size fits all. So, in your experience, how does the prosecution typically build a case for serious drug charges? And what are the key weaknesses that defense attorneys like yourself use to exploit?
Well, really from the state side it's very fact specific, which can be true from the defense side as well, but making that determination on, is this going to be a mere possession case, or is this going to be with intent to deliver or to traffic and distribute? Very fact specific. If somebody is arrested and they have a bag of whatever that drug may be, again, it'll matter what it is. Is it cannabis, methamphetamine, or something else, crack cocaine, and so forth? That makes a difference. Now, if that individual has multiple little baggies and they've been weighed out, or other items that they may be arrested with, like a scale, maybe having too much cash on you, among other things, well, those are indicia, or can be evidence, circumstantial evidence, that not only are you possessing whatever the drug is, but you're intending to sell it. So the state will look at this global set of facts. What are you caught with? How much of it are you caught with? And then are there any other little details that can let them know that, hey, they're not just possessing this, they're trying to sell it. Sometimes that's even the nature of the arrest. Was this based on a hand-to-hand transaction, or that an officer actually witnessed a hand-to-hand transaction? Or is it somebody had the misfortune of being pulled over and an officer smelled drugs, or saw something in the center console or something like that? There was a bag, or what will always be referred to as a green leafy substance, thought to be cannabis. Now, from the defense side, Yes, it's a global proposition. We want to know what the state has, but the first thought and the first question I always have, is it an actual possession case or is it a constructive possession? And without getting too much into the weeds, actual possession, the idea is you actually have this on your person. It was in your hand, it was in your coat pocket, it was in your waistband, where it's just on you. You actually literally possessed whatever it is they're alleging you had, they being the state. A constructive possession case is where the state's going to treat it as if you actually possessed it for purposes of the law, but because it wasn't actually on your person, it wasn't in your pocket, on your waistband, but maybe it was underneath your seat or it was in a bag in your car, the state will argue, well, it was your car. We're going to say this is your bag. You have knowledge of what is in your car. We're then going to assume you know what is in your bag. So we're going to charge you with possession or possession with intent to deliver, among other things, these drugs that we found. From the defense point of view, the actual possession cases are the most difficult because if the stop of my client, the search of my client holds up, if that holds up to scrutiny under the Fourth Amendment, that there was probable cause, reasonable suspicion to search my client, and then they find it, again, they being officers, the state, there isn't much more for us to do. If we lose on the Fourth Amendment claim, the case is kind of done. They've got my client. Now we're just negotiating, trying to get the best possible deal. With constructive possession cases, maybe the search was good. Maybe the stop was good. Everything legally could be good, but now we have other factors to consider. The biggest one usually is knowledge. Can the state prove that my client knew that those drugs or any contraband, but drugs specifically, were underneath his or her seat, that they were in that bag? So now we get more and more into the weeds of the facts. Was it my client's car or was it someone else's? If it was a bag, was it my client's bag or someone else's? What else was found in the car? Was it my client's ID, which would be bad, or was it somebody else's ID? I've had situations where my client is driving, he admits it's his car, they find drugs in a luggage container in the trunk, and they hit him with the drugs. Well, come to find out, there was a piece of mail within the luggage that was not my client. That creates at least some level of doubt as to, well, who packed this bag? Whose bag is it? Did he really have knowledge of what was in that bag? And we were able to beat that portion based on the knowledge component. There are some other factors like it being immediately accessible and so forth that we can have some arguments about. But typically, when we're talking about a constructive possession case, knowledge is the single biggest component or prong that we can win on. And that's the thing I look for. Is it actual or constructive? And then did my client say anything that could overcome knowledge, or are there some other circumstantial bits of evidence or direct evidence that can overcome knowledge? But those are the big things from the defense side: actual or constructive. What else does the state have? Are there any admissions, any independent type of corroboration, fingerprints, DNA, identification, mail, something like that, that can show knowledge, show possession of an item like a bag, like a car, things like that.
Wow, you just said a lot there. So, we've established Chicago clearly has had a long standing issue with drug related crimes. How have changes in local and state law impacted the defense strategies for serious drug charges?
Some of it's just from the decriminalization of cannabis specifically. Now, for better or worse, it has eliminated some cases from ever even being brought, or they get dismissed once we determine, or it's even better to say the state determines the amount, that they're not going to proceed on minor amounts of cannabis, even if they weren't possessed technically legally, because there's just bigger fish to fry. That's great. We've eliminated some really low level, non-violent offenses that, generally speaking, public doesn't care about anymore. It's been decriminalized, it's legalized in many respects. Now, that's great. The bad news is now that cannabis is largely legal in many respects for the recreational uses, well, there's still the smell of cannabis, be it burnt or fresh. Now, that in and of itself, the case law involved with just smelling cannabis is something that is changing, not on a daily basis, but there's been some interpretive case law even over the last less than a year that has changed what amounts to probable cause for an officer to now go and do what's called a narcotics search. Under old law, just any smell of cannabis, fresh or burnt, didn't matter. Didn't matter if they could see anything, if anybody admitted to smoking that day or a week before or never. Smelling it, that was an immediate trigger. They can search, they being the police, can search the car, and anything they find, be it a weapon or other drugs, that's going to hold up. That's going to be a legal search. And now it's not a question really about guilt or innocence so much. It's negotiating out the plea agreement. Well, Illinois just recently did change the smell of burnt cannabis as opposed to the smell of fresh cannabis. Burnt cannabis no longer in and of itself. If that's the only thing the officer can say that they smell is, I smell burnt cannabis, that is not enough to immediately trigger that narcotic search, which is good. But now it still keeps the door open for fresh cannabis, and how, on the defense side, how we know what an officer did or didn't smell. And call me cynical, but I believe we're not going to have officers smelling burnt cannabis anymore. They are always going to smell fresh cannabis because officers know the case law and are briefed by state's attorneys and their own union and so forth, so that they're doing things, air quote, right, in order to be able to hold up to scrutiny, Fourth Amendment scrutiny, private attorneys filing motions based on the Fourth Amendment, so forth. So there's been this mixed bag of some good case law, some good changes in the legislation. But at the end of the day, drugs are still a very serious charge. Judges take them very seriously. Officers love finding guns and drugs, and the mixture thereof is even worse. In Illinois, we even have specific charges that you had guns and you had drugs. Now, combine the two, you're looking at mandatory minimums that start in the mid teens because you had those two big no nos together. So, Illinois broadly, Cook County more specifically, while some things have certainly gotten better, a lot of stuff is very, very serious when it comes to the possession of any type of drug, pharmaceutical or otherwise, things that you can make at home and grow at home, or the types of things that you only see on Breaking Bad and so forth. Very, very serious.
So, how do you approach cases involving individuals charged with drug trafficking or distribution? And where are the stakes particularly high? And are there specific strategies that you rely on?
Sure. Like every case, you need to get into the weeds. You have to get into the specifics of the case. Is this really a trafficking or distribution case? Is that truly what it is? Or is the state just looking at somebody as too much of whatever it is that the client's accused of having? If that's all it is, he or she has a lot of X, Y, and Z drug. It's like, well, what evidence do you have that this is really trafficking? Now you get into the tougher cases where there are scales, being the defendant are arrested with individual baggies where it appears it's like, listen, this has been outright created not for personal use, but for distribution, for sale, because they're found with 40 individual baggies, and this is the way that this type of drug, again, depending on what one we're talking about, this is how it's distributed. This is how it is sold. They were individually baggied. They're all weighed out. Again, if there's any evidence that there were hand to hands, either with an officer or an undercover buy, or if they were just witnessed by an officer as a hand to hand, that gets trickier. But as a defense attorney, it's getting outside of the individual facts because that's part of it for being able to go to trial. Sometimes it's getting into the mitigating circumstances. Like, listen, my client actually has a drug problem. And this isn't necessarily to excuse why they had them or why they use them, but it's to try to soften that blow a little bit and negotiate with the state. It's like, listen, we're talking about somebody who has a drug problem. They're not some kingpin. They're not a huge drug dealer, even if that's indeed what they were doing. That's how they made a living. It's like, hey, I sold some cannabis here or there, or I sold some other type of drug. That's how I made money. It's not to excuse any of it. It doesn't make it less illegal. It's about softening it, humanizing my client to working out a reasonable conclusion to their case, or disposition would be the formal word we use, that we're going to negotiate. Hey, you've got my client. We've gone through the Fourth Amendment motions. This stop and search and seizure all hold up. They were found with it on their person. So there's not even really a knowledge argument. It's not constructive possession. So now we're just trying to soften the blow, try to get the best possible outcome. And that's humanizing the client and realizing their own background, that again, yeah, they're not part of the cartel. They're not a kingpin drug dealer. It's nothing like that. They're just a small fish in a otherwise much bigger game that's out there. And let's get them the help that they need. And sometimes that does still involve what can be prison time, jail time, but it can pale in comparison to what you actually see on an indictment when somebody's looking perhaps at decades in prison. It's like, let's get them help, let's get them cleaned up, let's get them through this so that hopefully they don't repeat this. And that's what the goal and the strategy of the defense attorney is, to get into the weeds of the case to see if we have a technical, legal, factual violation, or do we have a factual argument for a trial. And if those aren't available, or we end up losing on a motion, then it's, let's get to the heart of what's really going on here and humanize your client as somebody who makes mistakes, somebody who may have a drug problem, and let's see through that they're treated appropriately. And maybe we get this cleaned up and this can be an isolated incident and get them through. Those are all the different things that a defense attorney's thinking about in getting the best possible result for a client.
So, with the evolving landscape of drug laws, including the legalization of marijuana, how have these changes affected the way serious drug charges are handled in the courts?
At this point, I do believe that because cannabis, for the most part, there are still some examples of the illegal possession and even distribution of cannabis can be charged. But for the most part, we're talking about more hard drugs that if you're polling the general public, a vast majority of people say, yeah, I'm kind of uncomfortable with that being legal. I don't want that on the streets. I don't want this being offered to even consenting adults. There's no upside to this. This is bad. This is a scourge. That what we're seeing is there's a lot of enhancements. The most recent example, the one most in the news, would be fentanyl. That in Illinois, we have outright fentanyl enhancements. That, yes, it was bad that you may have had whatever the drug is, and maybe you had a lot of it that's going to make it serious. Well, now on top of that, if we believe that there is actual fentanyl lacing of these drugs, or there's fentanyl in these drugs, this bad outcome you're already facing is even worse. So the Illinois, the legislation has taken the drugs very, very seriously. And now our focus is on most of the hard drugs, crack cocaine, methamphetamines, fentanyl, among others, that we're not talking about recreational use of cannabis. That again, in many jurisdictions, including Illinois, is now legal. And most people just, it doesn't get your blood pressure up. We don't care about that. So now we're dealing with tough drugs, hard drugs, and cases that even with people who have drug problems, they really are, it's a mixture. Yes, they may have committed a crime, but they also have a problem. It's tougher to get through to the other side because of the drugs we're talking about. So when somebody calls me with a drug case, certainly there are possible defenses, there are constitutional arguments, there are factual arguments that we can make. But if we're talking about one of the more serious drugs and fentanyl and other types of enhancements that are there, these are not situations to take lightly. You want counsel. You don't want to wait. You need an expert who knows how to handle these types of cases because the consequences are dire. In some situations, and I've had clients say this. It's like I was better off like murdering someone than facing the penalties for a drug case. And the fact of the matter is that's true. You're better off actually beating someone else up, having a gun, actually injuring someone, than being caught with the wrong type of drugs or the wrong amount of drugs because of how serious the state takes these.
Wow, a lot to think about. Thank you so much for sharing all of that today.
My pleasure. Happy to help.
Thank you for joining us for Defending the Windy City. You can find David at www.drdlawllc.com. Please like, subscribe, and leave a review on your favorite platform.